Be ready. Start. Under section 125 bracket 1 clause a person who having sufficient means neglects or refuses to maintain his wife who is unable to maintain herself can be asked by the court to pay a monthly maintenance to her at a rate not exceeding 500 rupees. By clause B of the explanation to section 125 bracket 1, wife includes a divorced woman who has not remarried. These provisions are too clear and precise to admit of any doubt or refinement. The religion professed by a spouse or by the spouses has no place in the scheme of these provisions. The reason for this is axiomatic in the sense that section 125 is a part of the Code of Criminal Procedure note of the civil laws which define and govern the rights and obligations of the parties belonging to particular religions like the Hindu Adoptions and Maintenance Act. Section 125 was enacted in order to provide a quick and summary remedy to a class of persons who are unable to maintain themselves. What difference would it then make as to what is the religion professed by the neglected wife, child, or parent? Neglect by a person of sufficient means to maintain these and the inability of these persons to maintain themselves are the objective criteria which determine the applicability of section 125. True that they do not supplant the personal law of the parties, but equally the religion professed by the parties or the state of the personal law by which they are governed cannot have any repercussion on the applicability of such laws unless within the framework of the Constitution their application is restricted to a defined category of religious groups or classes. The liability imposed by section 125 to maintain close relatives who are indigent is founded upon the individual's obligation to the society to prevent vagrancy and destitution. That is, the moral edict of the law and morality cannot be clubbed with religion. Clause B of the explanation to section 125 bracket 1, which defines wife as including a divorced wife, contains no words of limitation to justify the exclusion of Muslim women from its scope. Section 125 is truly secular in character. Under section 488 of the Code of 1898, the wife's right to maintenance depended upon the continuance of her married status. Therefore, that right could be defeated by the husband by divorcing her unilaterally as under the Muslim personal law or by obtaining a decree of divorce against her under the other systems of law. Wife means a wife as defined irrespective of the religion professed by her or by her husband. Therefore, a divorced Muslim woman, so long as she has not remarried, is a wife for the purpose of section 125. The statutory right available to her under that section is unaffected by the provisions of the personal law applicable to her. The conclusion that the right conferred by Section 125 can be exercised irrespective of the personal law of the parties is forfeited, especially in regard to Muslims, by the provision contained in the explanation to the second proviso to Section 125(3) of the Code. That proviso says that if the husband offers to maintain his wife on condition that she should live with him and she refuses to live with him, the magistrate may consider any grounds of refusal stated by her and may make an order of maintenance notwithstanding the offer of the husband if he is satisfied that there is a just ground for passing such an order. According to the explanation to the proviso, if a husband has contracted marriage with another woman or keeps a mistress, it shall be considered to be just ground for his wife's refusal to live with him. It is too well known that a Mohammedan may have as many as 4 wives at the same time, but not more. If he marries a 5th wife when he has already 4, the marriage is not void but merely irregular. The explanation confers upon the wife the right to refuse to live with her husband if he contracts another marriage, leave alone 3 or 4 other marriages. It shows unmistakably that Section 125 overrides the personal law if is any there conflict between the two. The whole of this discussion as to whether the right conferred by Section 125 prevails over the personal law of the parties has proceeded on the assumption that there is a conflict between the provisions of that section and those of the Muslim personal law. The argument that by reason of Section 2 of the Shariat Act 36 of 1937, the rule of decision in matters relating inter alia to maintenance shall be the Muslim personal law also proceeds upon a similar assumption. We embarked upon the decision of the question of priority between the Code and the Muslim personal law on the assumption that there was a conflict between the two because insofar as it lies in our power, we wanted to set at rest once for all the question whether Section 125 would prevail over the personal law of the parties in cases where they are in conflict.